Good morning. I'm Ruthi Rajan, Deputy Editor of the Oath Legal Magazine. Thank you for joining the Oath GC Talk webinar series. This morning, our webinar is in association with the law firm Charles Russell Speechlys and legal research partner LexisNexis. On your screens, you'll see the topic we are covering this morning. In a challenging economy, we're witnessing many disagreements between partners where companies are often unprepared for the issues, some of which could have been avoided from an early stage. The session aims to explore mechanisms for avoiding and dealing with partner conflicts. The webinar will be led by William Rakert. Our speaker, William, leads Charles Russell Speechlys' Middle East corporate practice. He is a dual qualified lawyer with extensive experience advising on high-value complex deals in a variety of sectors, including technology, healthcare, energy, and natural resources, and real estate. William has more than 20 years of experience advising on matters ranging from seed series investments for startups to complex multi-billion-dollar matters across numerous jurisdictions. His experience includes advising on M&A, joint ventures, private equity and venture capital transactions, restructuring, and compliance matters. William will lead the session for the first half, and this will be followed by a Q&A session. There is also an option on the right side of your panel on both the laptop and the phone to type and send in your queries. Some of you have sent in your queries in advance. We'll address that first. As it is a session that is scheduled for 1 hour, we request you to send in queries that are relevant to our discussion today. Over to you, William. Thank you.
Thank you, Ruthie, and thanks to everyone for joining this morning. Next slide. And again, please, next. Oh, that's me. As Ruthie said, I'm head of the Middle East corporate practice for Charles Russell Speechlys, but you've heard enough about me, so next slide, please. So what we're going to talk about today. I would say that no one likes disputes, but that's not entirely true. My disputes partners like disputes very much. It's what they do. Our chief financial officer loves disputes because it's very, very profitable. I admit to sometimes being a little bit jealous when I see the kind of billings that my disputes partners have, because when you're in a dispute, that's not usually when you negotiate fees. You just want to get the right result. For me, I'm a corporate lawyer. And so whenever I'm doing a deal, always in the top of mind is, okay, how is this going to go down if there is a dispute? What can we do to avoid a dispute? And so when you are negotiating a deal, that should really be, in many ways, the first thing that you're thinking about. Because disputes are costly in so many ways. So, and there are a few things I've listed here. I mean, there are obviously the losses from a non-performing business. There are the external fees to lawyers, and again, they are significant, especially if it goes to arbitration or to the courts. And then there's the disruption. There's the amount of time that the internal team members have to spend dealing with the dispute instead of focusing on the business. It's not good for morale. It's not good for reputation. I mean, disputes are unpleasant in many, many ways. So we are going to try to cover some tips to hopefully avoid disputes in the first place, avoid getting into a bad business situation, what to do when you are faced with a potential dispute, and some of the consequences of that. So that's what we're going to cover. What we're not going to cover, we're not going to get into actual dispute resolution. I'm not an expert on that, and that's really a topic for another webinar. We're also not going to talk about formal settlement discussions when you're in that dispute context, and we're also not going to cover COVID-19 issues, just because I think that's been covered enough. The ironic thing is that I was actually supposed to give this very same presentation a little over a year ago. It was supposed to be live. And I think I actually changed the title a little bit. I think I called it at first Preparing for Trouble. And then I thought, oh, well, I didn't think to prepare for that. And none of us did. So again, I think issues related to COVID-19 have been covered plenty. So we're not going to talk about that. Next slide. So before we get into what disputes are like, I think it's important to think about what business relationships are like, especially when you're starting out in that business relationship and before a nasty situation has arisen. Next slide. And there you go. That's sort of what it's like at the beginning of a business relationship. It's, there is this sort of initial romance and everyone's happy and everyone thinks, oh, this is going to be so wonderful and we're going to make lots of money and boy, aren't our business partners great. And it's a very exciting time. And in fact, as a lawyer, and I'm sure the lawyers in the call have faced this a lot, especially probably if you're in-house and you're dealing with the business teams. When you're asking the difficult questions and the business team, they just want to sign an agreement. They don't really care what's in it. They just want to start making money. And you start pushing back and say, no, we need to think about this. People get annoyed because they are so excited. But as lawyers, we're paid to anticipate the problems, and we know that it's not always as rosy as it seems in that initial sort of courtship period. Next slide. So, you do get married in your business relationship, and you have your new partner, and hopefully things go well. Hopefully, in some ways, the best thing that happens after you sign a contract is you never look at it again because the business has gone so well and everyone's making so much money that no one really even cares. And that's a great situation to be in. But that's usually not the way it happens. Most business relationships, you hope, if you've done your due diligence and picked the right business partner, will be good and successful, but there are always going to be some problems. Next slide, please. So yeah, as I say, there are always going to be some problems. There are always going to be some disagreements, even in the best of relationships, business relationships, personal relationships. They're going to be challenging times. Next slide, please. But hopefully it doesn't get too bad. I love this slide. Whether intentional or not, if you look at this woman, I think it would be hard for her to argue that was not intentional. I was just, happened to be walking past the bathroom with a toaster and I tripped. I don't think so. Of course, what's the big mistake she's made? It's not plugged in. So remember, if you take anything away from this seminar, and you might want to write this down, if you are going to try to kill your spouse with a toaster, make sure to invest in a good quality extension cord. No, I'm kidding, of course. Please don't try to kill your spouse, whether with a toaster or anything else. I'm grateful to my wife, as well as my ex-wife, for not trying to kill me with a toaster, even though I may have deserved it at times. Anyway, so next slide, please. And this is what happens when you can't work out your problems. It goes to court, and that's not fun. And divorces, whether personal or business, are messy. They are not productive uses of people's resources and time. So that's what we're going to try to avoid. And hopefully I'll give you some tips on ways to do that. Next slide, please. So when thinking about a possible dispute and ways to avoid it, the first thing to do is think about the type of business relationship, because all relationships are different, business relationships that is, and some are more prone to disputes than others. So next slide, please. Let's look at some of those. So these are some of the ones that are more likely to lead to disputes than others. So agency and distribution agreements, franchise agreements, other types of collaboration, partnership, etc. These are all business arrangements where the parties have to work together. So when there is a lot of that interaction, and especially when it comes to making money together and how to share that money, that's when disputes can arise. Next slide, please. So let's take a quick look first just as an example, looking at joint ventures. And the reason I chose joint ventures is because joint ventures can be very complex relationships. There are a lot of moving parts, whether it's finance, operational, management, et cetera. There are a lot of things to take into consideration, and sometimes these are very, very high value, high stakes. The parties have contributed a lot in terms of capital, in terms of personnel, and there are also, you see a lot of joint ventures, if not strictly joint ventures, then some sort of partnership in this part of the world, particularly with the local ownership requirements. It's very common, and I would say that in my time working in this part of the world, as opposed to some of the other places I've worked, I have seen a higher proportion of breakdown of those relationships than I have in other jurisdictions. And I think that is because of the local partnership requirements, local ownership requirements. And when things break down, they can get quite nasty. So, and I guess another reason I chose joint ventures is because they are sort of these complex, all-encompassing arrangements. Most times the agreements are going to contain all of the various provisions that you're going to find in other business arrangements, and especially those that can result in disputes. So I've just listed a few of the ones that are most commonly lead to disputes. So financial contributions, both at the beginning and then ongoing financing. Ongoing financing in particular can be a thorny issue. Extracting value, dividends, decision-making, that can be challenging, especially when you have issues of reserved matters and veto rights and things like that. Restrictive covenants, dealing with problems, liability, et cetera, et cetera. Those are all areas, and there are others, of course, where disputes can come up. Next slide, please. So, how can we try to avoid some of those disputes? The first most important thing is do your homework. Hopefully you're doing that, and your colleagues are doing that, and you really have to do it from so many aspects. Financially, a party can be very good in so many ways. They can be good operationally, they can be the right fit for you, they can have very good technical skills. If their finances are shaky, and halfway through they're having problems, that's going to affect the relationship. So very important that they're financially stable. It's important when doing due diligence to not focus only on the legal and financial and technical due diligence. Very important that whoever is doing it checks out reputationally how your counterparty is. So if someone isn't doing that, if whoever is leading the deal has assigned legal and financial due diligence, and no one is really going and asking around, and there are services that will do this. There are companies that specialize in that, in sort of doing reputational due diligence. Very, very important. Related to that is culturally. Do they see the world and see business in the same way? And I've sort of highlighted this. Does it feel right? Sometimes you just know. Sometimes it's not something you can write down on a piece of paper. It's not something you can analyze in a graph, but it just doesn't feel right. And it sounds a bit odd sometimes when, as lawyers, we're really tasked with finding evidence and making arguments. And sometimes it sounds a little funny to say, you know what, this just doesn't feel right. But usually, if that's the case, everyone kind of knows it, and it's usually right. So trust your instinct. So very important to do due diligence from the beginning, thorough due diligence, but also keep doing your due diligence after the agreement is signed, after operations have start. Very important. There is an ongoing program to regularly evaluate and assess things, see how things are going, get feedback from internal team members, have a dialogue with your partner. And if things aren't going right, if there are things, or even if things are going right, but there are certain things that can be done a little better perhaps, then take a look and revise, revise the agreement, revise the relationship, and hopefully that will help avoid any problems. Next slide, please. So when doing your diligence, ask the hard questions. Okay, remember this is very different from when I talk about avoiding disputes, it can be in all sorts of business relationships, but going back to the question of a joint venture is much different than an acquisition. Okay, an acquisition, you can sort of afford to play hardball and well, quite frankly, be a little bit nasty if you have to with your counterparty, because if you're completely buying them out and not just making an investment minority or majority, you're done. Once the deal is signed, I mean, there'll be a liability period, et cetera, but for the most part, you're not working with them anymore, unless management is staying on, et cetera. But with a joint venture or other partnership, this is who you're stuck with for a while, and that's why it is like a marriage. And so ask those tough questions at the beginning, because you don't want to find out something that is unpleasant and could have been avoided later on. So do we really have to do this? Or are we being compelled to do this? What are they contributing? Are they contributing an equal amount in terms of what we're contributing? And what are the consequences of things not working out? So something I always go by, sometimes the best deals are the ones you walk away from. So the deals you don't do, because if you end up with the wrong deal, it can be very costly in so many ways, just like I referred to at the beginning. Next slide, please. So if you've done your due diligence and you think, okay, you know what, this looks like something we want to do, this makes sense legally, financially, commercially, et cetera, then it's time to do a deal, and time for negotiations and drafting. So I'm going to try to give you a few tips to help you through that process, and make sure that everything after that goes smoothly. Next slide, please. So preparation is really essential. It's very important to prepare for negotiations, and that does not mean just signing, a term sheet or an LOI and knowing the terms of it. It's really a question of having a strategy. So talking with the team internally and thinking about, what do we want to get out of this? What are the goals? What do the parties need from each other? Is it capital? Is it technical expertise? Is it access to their network? And make sure to focus both on what your obligations are and also what you're getting from the other party, and make sure that's well documented. Okay, it's very important. I think sometimes parties have a tendency to just focus on obligations, legal obligations, in the documentation, and they forget to include technically, what is it? It's very helpful sometimes to have all sorts of schedules, even though they're not necessarily legal. It's an important reminder of why did we sign up in the first place with the counterparty? What are they bringing us? And I think the more detail you have, the better. And that's why you get sometimes these agreements that are 100, 200 pages long, because there is so much detail. But the more detail you have, the better, and the less likely you are to have a dispute, because a year, 2 years later, when no one really remembers what was agreed, you can go back and take a look and see, oh yeah, that's what we were supposed to be doing. So as I said, have a strategy, and that requires some internal negotiations first. Very important that everyone's aligned. There's nothing worse, well, I won't say nothing worse, but it's really very difficult and harmful. And I've seen this a lot when you get, especially a large team that is negotiating, and people aren't on the same page. It confuses the counterparty. It weakens your negotiating position. So very important that there's some internal agreement first. In doing that, you have to, I think, map out both what you really ideally want to get out of it, but also sort of the minimum you're willing to settle for. And if you don't get that, and it's very, very important to write that out, because I think during the dynamics of a negotiation, people can get lost in the detail and forget, why did we want to go into this in the first place, and what is the absolute minimum for us? So very important to have that set up very clearly. In preparing, try to anticipate issues that can come up, problems that could come up, and possible solutions. I would note, what's most important, what are the things that you're not willing to trade off, and those that, well, okay, we can live without that. There's got to be some give and take in negotiations. It should at least feel win-win. I like the statement that a good negotiation is one where neither party is really completely satisfied, but generally satisfied. That's important. When preparing your strategy, consider the outcomes and the impact that can have both on the future business relationships, both with this partner and with other partners, reputational issues, etc. Next slide, please. So during negotiations, hopefully you've made that strategy, you know what's important, you know what you want to achieve, and it's important to keep that in mind. Very frequently, as you'll all know, when people go through documentation, it's usually a page flip. That's the way people most often do it. Sometimes that's helpful. I think, quite honestly, that's helpful at certain stages. I think at other stages, it's better to get an issues list. I think it helps focus the mind and not get lost in the weeds. So if you don't do that, if you do just do page flips or just have a list of points that aren't really set out in terms of importance, you can sort of get lost and lose focus on what's important, and you end up just sort of haggling over things that really aren't as important to you. Make sure you can justify what it is that you want, okay? And that is particularly important for those more important positions. And try to be objective and realistic, okay? You have to remember that your other party is going to want something too, and you're not going to be able to get everything. And in that sense, it's very important to listen, to ask questions, and to listen to what's important to your counterparty. And that will give you some idea on the areas where you can cede and give up some issues, and the ones where you really dig in your heels. And also that may just give you an idea whether they're just deal breakers. And so, I've underlined that because you have to ask the difficult questions, because you want to find out if there are deal breakers. Don't be afraid at this time to ask the uncomfortable questions. If you see problems, don't worry about embarrassing the other party or making it uncomfortable. It's better that you deal with that now than later on after you've signed the agreement and say, oh, we should have listened, we should have looked into that, we should have asked that, and regretted it afterwards. During actual negotiations, keep your eyes and ears open for non-verbal cues, just the general feel, body language, things like that. You can often tell what's important to someone and what's not. Be very careful of splitting the difference. That's something that's, it sort of feels easy to do. It's kind of a lazy solution, quite honestly. If they're asking for 100 and you're only offering 50, don't just split it 75. Say, well, why are you asking for 100? We've done our analysis. Here's our analysis of the revenues, and 50 seems justified because of this. Make them justify their numbers as well. Be commercial. Don't waste a lot of time arguing over silly things. It wastes your time. It wastes the other side's time. If you got lawyers involved, external lawyers, you're just racking up legal fees that you don't need to. So be careful about that. And I think most importantly, try to remain calm. People can get very wrapped up in emotions during negotiations, and that's a really bad thing to do, because then you're going to lose focus of what's important. So try to remain calm and be objective. Next slide, please. So let's talk about drafting, because this is where our job as lawyers really is the most important. So many disputes arise from language that just no one understands, and that can be because either it was poorly drafted or it's something, when you're in a deal, there's this constant dialogue going on over rather technical matters, and so you will understand it at the time, but you have to sort of step back and say, okay, let's pretend I'm a judge, or sit on an arbitration panel, and I'm looking at this, and I know nothing about this. Is this going to make sense to me? And so you have to really sort of step back and see if that makes sense. So very important to understand what you're drafting, and I think that probably most lawyers have made the mistake at some point in their career. Hopefully, not so much when they get a bit more senior, but certainly when they're junior. You just draft something because, oh, well, I don't know, I saw it in a precedent, or that's what was in the term sheet, and so yeah, I guess it makes sense. I don't know, I'm just a junior lawyer, and I'm sure the business people understand. It's not always the case. It's not always the case, and usually, if you don't understand, good chance other people don't understand too. And so don't be shy. Don't be afraid to ask whether someone else more senior in your team, or even ask the other side if no one understands. Say, you know what, this doesn't make sense to me. Can you please explain this? And don't assume that your team members, your clients, whoever understands, because they're, as the attorney, they're relying on you to understand. So very important that you understand what it is that you're drafting. So some other things to do. I'm a big believer in just simplifying the drafting. So one thing I just can't stand is these sentences that are this long. It's a one huge paragraph, and it's all one sentence, and it's got subclauses and refers back with conditionality and things, and it just makes your head hurt. If you're reading that kind of stuff, that's not good drafting. Sometimes it's hard to avoid it, but usually it can be. Usually just break down the clause, break it down into sentences, simplify the terminology. Very important, I've always found, if there are formulas for, say, how revenues are split, or what to do when calculating dividends, etc. Very, very helpful to put in examples. I think that makes a big difference. Not just a formula, but also saying, here's scenario A. If there are these kinds of revenues and how it's split, etc. Here's what the result would be for shareholder 1 versus shareholder 2. Put in a couple of those. That can be helpful. Very, very important. Do not draft in haste, and this is particularly true when you're getting late night. People get tired. They just want to get it done. Sometimes you have to do that. That's fine, but then reread it. Okay, very, very important. That's something I've always believed very strongly in. I always reread things at least once, if not twice. I can't emphasize that enough, to read things, especially when it's a long document. You can read it, I mean, at some point you have to just say, okay, stick a fork in it, it's done. You can't read it forever, but the more you read it, the more you'll pick up. So again, if you don't understand it, it's unlikely that a court will, and at the end of the day, we have to bear that in mind, because that may ultimately be who decides. Next slide, please. So it's what I call stupid drafting. Okay, this is mistakes that really could have been easily avoided, and unfortunately they happen way more often than they should. So first question, are you using the right precedent? Don't just take the shareholders agreement or whatever, the investment agreement from the last deal, just because it's the first one that comes to mind. That's not, it might work, but it's may not be the most appropriate document. So very important to start off with the right material to begin with. So take the time to find a good precedent, and make sure it's the right one. Okay, it's don't, if you're using a document from a previous deal, make sure it's the first draft, not the negotiated draft. Unless, of course, if the negotiated draft turned out in a way that you liked and you want that same position, okay. But usually you're better off with the first draft. And make sure that that draft is friendly to your position. That's important as well. And I also think it's important, don't go overboard. If you're the buyer and you take a buyer-friendly precedent, don't be unreasonable, because it's just going to piss off the other side, and they're going to be like, oh God, do we really want to waste our time on this? It depends on your negotiating leverage, of course, but for the most part, try to take a reasonable approach, so you're not wasting everyone's time. Some other thing, don't just skim over the boilerplate or ignore the boilerplate, okay? It's important to read that through, maybe not on every turn of the draft, but certainly on the first turn of the draft, last turn of the draft, and maybe at some point in between them. Now, speaking of boilerplate, I've seen this before. Fortunately, I haven't seen it that many times because it's just a stupid mistake. Sometimes, for whatever reason, if you've got, I don't know, a party in the UAE and a party in, say, Germany, and they can't decide on the governing law, and they're deciding between English and UAE and German, and they just sort of leave that as one of the points to be decided towards the end, and it becomes one of these bargaining chips. And you negotiate the whole deal, and you've been fighting, and you were going to do English law, and said, no, let's do German law, and you just put in, this agreement will be governed and interpreted by the laws of the Republic of Germany. That is really, really, really stupid, because it can have a massive impact on the provisions of the agreement. There's a good reason why people choose English law. I won't get into it, but just very quickly, it's because it's very flexible and it's well known. And so usually, if you're doing English law, that's a safe thing. But don't be negotiating a document that was drafted under English law and then all of a sudden changed to Dutch law or something else like that. And if you do change, make sure that local counsel reviews it carefully. Deal fatigue. It always amazes me how hard people will fight for important points in week 1 of the deal, and then in week 12 of the deal, they're like, yeah, okay, fine, let's just do it. Do whatever. I mean, really, has it all of a sudden become unimportant? Again, going back to preparing for negotiations, be prepared and understand what you want, what you expect to get out of it, and what the bottom line is. And same thing, going back to what I said before, these deadline sessions, and that probably drives me nuts more than anything, because it's often related to deal fatigue. People often will pick an arbitrary deadline just because they want to get done with it. They want to move on to other things, which is understandable. But it just amazes me how you will have 20 important issues, and you decide 10 of them over the course of 2 months, and then in 2 days you're supposed to decide those other 10, and people say, yeah, okay, fine, whatever, and that's very, very dangerous. Going back to the question of, or the point of rereading things, if you do have those late night sessions and people say, okay, let's sign, I have often insisted, no, well, I mean, at the end of the day, the people who are signing, they get to decide, but insist strongly, look, we've been negotiating this for 2 months, 4 months, 6 months, whatever. Let's wait 1 more day just so we can all get some rest and read through it. And it's amazing what you discover, and better to discover that before you sign than afterwards, and either trying to amend the document or just having to live with something you didn't really expect to live with. Next slide. So when drafting, there are some provisions you have to take more care with than others. Even though I said, review everything, including the boilerplate, you don't have to spend as much time on the boilerplate as you do certain other provisions. So this is just, a few of the provisions that more commonly can cause problems, that are usually the subject of more detailed negotiations, and also tend to result in disputes more often than certain other provisions. So restrictive covenants, non-compete, non-solicitation, exclusivity provisions. That's particularly important when it comes to things like franchise agreements, distribution agreements. What does it cover in terms of products, in terms of territory, in terms of time? Are those clearly defined? Is the territory clearly defined? Have you defined MENA as opposed to the GCC or something else? And make sure those definitions are very clear. Damages provisions, I think that of all of the provisions, those are the ones, as I'm sure most of you know, tend to get negotiated the most, and they're very, very important for obvious reasons. So make sure to pay attention to those. Termination provisions, that's obviously important in drafting, because if you do have to terminate, you want to make sure that you have the right to do it, that you understand what your rights are, that you understand what your counterparty's rights are, that they can't terminate for reasons you didn't expect. So think about the conditions for claiming default. And sometimes it always amazes me, people just forget to include a termination provision. Well, then what happens? Does the thing go on indefinitely? Do you have the right to terminate on notice? Tough question. It depends on the circumstances, depends on governing law, depends on all sorts of things. But make sure that you do spend some time on the termination provisions. And again, don't just take the last precedent. Talk to your team members and make sure you understand what when things go wrong, what your rights are. And then the dispute resolution. That's not just a typical boilerplate provision, even though people think it is frequently, and they just include it. Think about it and consult with the disputes specialist. Not just if, again, for me, I'm a corporate lawyer. I've been doing this a long time, and so I know a little bit about disputes. But when I get into a more complicated situation, and the dispute resolution clause is something where it may be a little bit different. I check with one of my partners and make sure it's okay with them. Next slide, please. Another area where disputes frequently come up, and that's in the decision making and avoiding deadlock. So pay a lot of attention to the rights of the board of directors and things like that. 50-50 joint ventures that can run the risk of deadlock very easily. Reserved matters where there are veto rights, there you run the risk of deadlock. So just be very careful to understand that, understand the provisions behind the voting, behind all the rules that govern board meetings and shareholder meetings, etc. And it's also helpful, as I put there at the end, escalation to senior officers before there's an actual declaration of deadlock. That can be helpful. Next slide, please. Also very important, what I call the dispute-related provisions. And so that is, if there is a dispute and there is going to be some sort of termination right, and maybe one party buys up the other, or the company is liquidated, valuation, that's an area where there's often a lot of dispute. I mean, I would say more often than not, in fact, when you actually get into a valuation discussion, there may not be a dispute in the sense that it goes to an independent expert or to arbitration in the courts, but there will be a discussion and there will be disagreement. So make sure that that is very, very clear in terms of the drafting. Make sure that you have objective criteria to calculate the valuation. Make sure that you have the rights to see all the backing, the books and records behind the valuation, and be very careful on drafting the mechanism to challenge the calculations. Consider getting an expert in, whether that's binding or not, to resolve any disagreements over the valuation. Similarly, for default, is it clearly defined who can claim default and why? Be very careful with things that are not clearly and objectively defined. If if a party has to use its reasonable efforts and you're claiming they didn't use their reasonable efforts. Who decides what reasonable is? Has there been a material breach? Okay, is material objectively defined, or is it been left vague? So, and then again, the dispute resolution, right to terminate, those are all important provisions. Oh, I guess in terms of right to terminate, do you have a right to just terminate, whether on notice, with cause, without cause? Again, don't forget to put in a termination provision generally, but also whether you need to have a breach by the other party to terminate. Next slide. After execution, don't just let the contract sit there. Review it, discuss it with the business people. It should become an interactive tool. Make sure you're complying with the terms so that you're not subject to termination by the other party because you have failed to comply with something that you should have. Have regular discussions, regular contract reviews with the other party to make sure everyone's happy. So it's just very important to have good contract administration generally. It helps monitor things and just will help avoid disputes generally. Next slide, please. So what to do when problems do arise. Next slide. So here are some things when sort of escalation procedures, whether this is put into the documentation or not. If you have early problems or early warning signs, you may just want to escalate that to the management board, or whether there's a separate committee that's been established to independent executives, experts, etc. And then if that can't be resolved, you may want to go to mediation or litigation and eventually terminate or go to a settlement agreement. But hopefully you can resolve things before it gets to that. Next slide. So just a quick list of common events of default. Obviously a breach, whether that's failure to fund or not performing according to the standards. So again, very important that that's clearly drafted in terms of what is poor performance, change of control, insolvency-like issues, failure to make payments, etc., force majeure. What are the consequences of default? That is often no more voting rights, no more decision-making powers, financial penalties. They may have to pay default interests on JV financing, put in call options at a premium or discount as appropriate, and whether the continuing party can appoint a replacement or whether the JV has to be wound down, etc. Next slide. One thing that's very important, make sure to, this goes back to the question of monitoring, always monitoring the business and the relationship. Keep an eye on your counterparty and make sure they're not struggling, especially at this time in the history of the world. There are still a lot of companies that may be vulnerable from the pandemic, even if they seem fine. If their counterparties are having trouble and not paying their bills, that may bring your counterparty into trouble. So very important to keep an eye on them, and everyone should work together to identify potential warning signs. And here are a few of them: recent redundancies, especially director or executive level, and especially if, for example, if the CFO all of a sudden resigned, that's interesting. Do they not want to sign off on the accounts anymore? Have there been significant changes to the business? They're rebranding things because they're desperate to get more revenues. Have there been delays in payment or changes in payment terms? That can show a cash flow issue. It may be helpful to check whether there have been new pledges or security registered. That can show that they are looking for new methods of financing. And then just simply, how is that industry doing? How are their competitors doing? How are their customers and suppliers doing? Because if you see them struggling, that can be a sign that your counterparty is struggling. Next slide. So if you are in a dispute-like situation, make an assessment of your counterparty. Consider their perspective on things, whether they're unhappy, and whether things could be renegotiated, transformed somehow. What are they like generally? Are they litigious? And do they have deep pockets? If they do, you better be careful, because you might get yourself involved in a very long and costly fight. And then think about, is this even worth fighting about? If you bring a claim, do they have sufficient resources to cover that claim? And if they do, where are they? Are they in a jurisdiction? If you get a judgment, are you going to be able to enforce that judgment? So that's really, in some ways, the most important question. And then think about your position vis-a-vis them. What are your strengths and weaknesses? What are your rights under the contract? And if there is a dispute, how will that affect you in the long run, in terms of your business, in terms of your relationship with them, and in terms of your relationship in the marketplace, et cetera. I think when there is a dispute, I think it's very, very important that each party feels like they're getting something out of it. I've seen a lot of scenarios where a party realizes, wow, we're just, we have no chance, and we're not going to win this. And then sort of the gloves come off. Say, well, you know what? Let's fight it. That can be very dangerous. A party that feels like they've got nothing to lose. Next slide. So before you get into, before you actually make a claim or get into discussions, very important to gather your evidence. And so, again, I think any business relationship, any contract, you always have to anticipate the possibility of a dispute. And so during the course of the relationship, very important that you document everything, because you never know, hopefully you won't need it, but you never know when a dispute might come up. And so make sure that you're archiving all correspondence. If there are meetings and phone calls, very important to take notes and minutes, and either keep that internally or email them to the counterparty saying, here's a summary of our meeting yesterday. Very, very helpful, and make sure you can locate all that. If you are in a dispute-like scenario, don't offer any sort of resolution unless it's done without prejudice. And then make sure to keep documentation after termination. So 6 years as a general rule is usually sufficient under most statutes of limitations, but it depends on the governing law, the relevant contractual provisions, et cetera. Next slide. So understand your position if you're going to be getting into a dispute, whether you're initiating it or you think the other side may be initiating it. Review the underlying contract very, very carefully. Know the termination triggers. Understand the strengths. It's important to start now, not when a dispute arises, to know the strengths and weaknesses of any contract, so you can sort of defend yourself and position yourself appropriately. Very important to understand the provisions for bringing a claim, because if you are required to bring a claim within, let's say, 90 days or 6 months from the time that you're aware of it, that's the time you have to negotiate. Don't wait till the last minute to do that. If your counterparty, again, appears to be in financial difficulty, ask them for their latest accounts. And do some digging, see if you can find out from public information. Are you going to become, if they go insolvent, will you be a creditor, and do you have any security? Who stands in line before you? Also, very, very important, if you may have a claim, and that is something that could be covered by insurance, do you need to alert your insurers? So check your insurance policies. Next slide, please. In terms of negotiations during a dispute, same thing that I mentioned before in that previous slide. Write down what are the goals, what are the desired outcomes, what are the acceptable outcomes. Write down solutions and alternatives. Be commercial, and again, remain calm and objective. One thing that I think is very important in all negotiations, and this is a tough rule to follow, I think, for a lot of people, but it's very important. Listen, keep your mouth shut and listen. It's amazing often what the other side will offer that you didn't expect. And I think that's very important. You know, maybe don't come with a proposal, but just come and explain the issue, explain the problem, explain your concern, and then see what they have to say. Let them make that first move, because you might get a better deal than you would expected, and you don't want to negotiate against yourself. Make sure the people in the discussions, both on your side and the other side, have the decision-making power. Document the discussions, and again, say it without prejudice. And sometimes, you know, getting right in a formal claim is really what it takes to get attention from everyone. By the way, I realize we're getting short on time, so I'll try to go quickly through the last couple of slides. Next one, please. Renegotiating the deal. Again, I think just important, if you do renegotiate, make sure you're not waiving rights if there has been a default. And sometimes threatening to terminate is effective. Next slide. But again, if you do threaten to terminate, think very, very carefully about that. You know, will that put you or the counterparty into insolvency? If so, then you're really in trouble. How will that affect your long-term relationship with your counterparty or with other parties? What if you threaten to terminate? Say, okay, fine, terminate, and you really didn't want to. Make sure you're serious about that. Think about whether termination it can cause, it can trigger a default under financing arrangements, whether for you or your counterparty. That can be a real problem. And then if you do have the right to terminate under the contract, or if you don't have the right to terminate and you make a claim for termination, you could face a claim for damages for wrongful termination. And on the contrary, if the termination provisions have been triggered, but you don't terminate, you may be considered to have waived your rights. So again, it's important to note that reserve your rights at all times. Next slide. So again, consider the consequence of termination, how easy it will be to find a new partner, litigation problems or licensing problems that could arise, tax consequences, reputational issues. Are you going to be seen as a difficult counterparty in the marketplace? Financial consequences. What do you do with remaining stock? If there are financial guarantees involved or inter-party loans. Shared resources, how to untangle those, IP rights and licensing agreements, non-compete and restrictive covenants, what happens with those. Next slide. And then if you do actually look at dispute resolution, remember the cost, the legal fees, again, the time and the distraction from the business, reputational issues, and not being able to know what the outcome will be. Even if the contract doesn't call for it, you can still use ADR. Just because it says any disputes will be submitted to the courts doesn't mean you can't agree with your counterparty to go to an independent expert, to mediation, etc. And courts or arbitration should really be the last resort. Next slide. Very important to understand the dispute resolution provisions. Hopefully they are the same provisions if there are multiple contracts. It's the same provision for all. If not, it can get messy. Very important enforceability. Again, it's no use bringing a dispute if you're not going to be able to enforce a judgment, whether here or in other jurisdictions where you need to enforce it. So very important to think about where assets are located and whether you can enforce it. How arbitration friendly the chosen jurisdiction is. And again, with all of this stuff, very important to talk to a dispute specialist. I think that's the end. Next slide. I think that's the last slide. Yeah, well, there's some, sorry, propaganda about our firm. Next slide, please. And that's it. So apologies, I know that I've gone a little bit over time, so I'm happy to answer some questions if we still have time for that.
Yes, thank you, William. No problem. I think we'll go through some of the questions. I think it'll be helpful for our attendees as well. So we have received some questions here. I'll go through them quickly. I'll read it out and then you can respond to them. So what are the most effective ways to ensure JV partner funds the JV company?
Well, I mean, I think the most important, the most effective way is make sure they have sufficient funds to begin with. So again, going back to this question of due diligence, most important thing you do before getting into a relationship is make sure it's the right partner. And like I say, even if the partner is technically, operationally good cultural fit, if they are not stable financially, that can ruin the whole thing. So I think that's important, that they just have funds to begin with. And then I think in the JV agreement, you have to make sure there is sufficient motivation for them to pay. And that, sometimes those measures have to be pretty draconian, even if you wouldn't actually enforce that, just the threat of enforcing that. So whether it is loss of voting rights, payment of default interest, call options at a discount, et cetera, that should encourage them to fund, to meet their obligations to fund the JV.
Thank you, William. The second one we've received is, what are common warning signs revealed early on that should prompt you to walk away from a deal?
Well, hopefully you'll discover those in your due diligence. Again, whether those are financial issues or you discover, wow, they've got a lot of litigation, and so either they have problems with their business or they themselves are very litigious. So again, I just can't emphasize enough how important due diligence is. And like I say, it's not just the tangible due diligence, really important to understand your counterparty and their reputation. So sometimes that takes doing some inquiries, hiring a firm that specializes in doing reputational due diligence, and understanding who they are. And then I think, as I mentioned earlier, you have to ask yourself, does this feel right? We just were advising one of our clients on a what would have been a rather significant transaction. It was a proposed joint venture, and they eventually decided to pull out. And this had nothing to do with the counterparty in terms of their abilities or finances, et cetera. It's actually a very good counterparty operationally, a very good brand name, seems to be stable, well run, et cetera. But quite honestly, they were just so difficult. And I think that for whatever reason, the two parties couldn't see eye to eye. And maybe it's unfair to say they were difficult. Maybe it just wasn't the right fit. But I think they decided, what, if negotiations, remember, this is going back to the little cartoons I showed at the beginning with the idea of a business relationship being like a marriage. This is the romance time. This is when everyone is supposed to be showing how nice they are. If things are this difficult now, what's it going to be like when things get nasty? And so I think it's very important to think, does it feel right? It sounds like an easy, silly question, but it's actually a very important one.
Thank you, William, and thanks for sharing that example as well. So the next one is to have transparency in the agreements covering all terms and conditions, and to avoid disagreements. Is there a standard template? Sorry, I hope you followed that.
Yeah, I think so. I mean, I don't know that there's really any standard template. Again, this is not because, I don't make money by the word or by the page, but I do think there is an advantage to having more detail. The business people get annoyed at that sometimes because, like, God, do we really need this, 50-page agreement for something that's really pretty simple? Hopefully you don't need it, but often you do. And so the more detail you have, the less likely there is going to be a misunderstanding. Because remember, when someone is looking at that agreement 2 years later, whether it's the business people on the inside, they may not have been involved in the discussions, the negotiations, or even if they were, they might not remember. And so, you shouldn't assume that someone else will, especially if that's a judge. Going back to another thing I said earlier, I think it's really helpful for those financial calculations to include worked out examples. I've been in a number of situations where that has come up. People aren't sure how to calculate something they've agreed to, and having those examples has avoided some really nasty disputes sometimes.
That's great advice. Thanks, William. The next one, if we have renegotiated some of the terms of our agreement over the years, example, following market changes, adjusting certain commercial commitments, etc., is it always necessary to amend the agreement?
Yeah, I mean, I guess maybe it's not always necessary if it's something really minor, but generally I would say yes. Certainly if the new terms that have been renegotiated, if they're material, then yeah, you really should. At a minimum, I would document these things in an email exchange or something. But again, you have to bear in mind that that might not be enforceable. So take a look at the entire agreement clause in your contract. Most times it says that the contract can't be changed unless it's agreed in writing and signed by the parties. So an email may not be sufficient. So maybe not always if it's really something sort of minor, but you're better off amending things and having it in writing and signed by the parties.
Thanks, William. Now we have a question here that's often asked, but still very relevant. Is arbitration preferable over litigation?
Well, I'll first of all caveat that and say again, I'm not a disputes lawyer, but I have certainly dealt with that question enough times to at least have some thoughts on it. It's tough to say. It really depends. It depends on so many things. It depends on the transaction. It depends on the party's preferences. It depends on, I think, a very important issue, very, very important, is it depends on where the parties are located. I've heard, generally speaking, I've heard people, and including disputes lawyers, argue both sides of that coin. Sometimes it depends whether they're more arbitration specialists or litigation specialists, and I don't have to tell you which side each particular set of attorneys will side on. There are definitely advantages to arbitration, such as confidentiality. You don't have to wait for the other party to lodge an appeal. You can pick the arbitration panel and make sure that they are well versed in the relevant subject matter. But so going back to what I was mentioned just a second ago, though, I think when it's an international deal, so parties from different jurisdictions, I almost always recommend arbitration, and that is for the enforcement of the judgment, because not all countries, but most countries are signatories to the New York Convention on Enforcement of Arbitration Judgments. And so, if you're trying to enforce against another party and their assets are located in their jurisdiction, if you're not bringing a claim within the courts of that jurisdiction and you're trying to enforce a foreign judgment, forget it. It's just not going to happen. I mean, arbitration, I should have mentioned this earlier, I guess. I mean, not only is arbitration or litigation expensive in terms of the lawyer's fees, in terms of the disruption of the business, et cetera, enforcement is very, very hard and very expensive. So you may have, expended literally, hundreds of thousands, if not millions of dollars in attorney's fees just to get a judgment. That's only step one. You got to enforce it. And if you have a court judgment and you're forced in a foreign jurisdiction, forget it. It's just not going to happen. You're almost never going to be able to enforce that, practically speaking. Arbitration judgments you can, so for that reason, I recommend arbitration in those circumstances.
Okay, thank you, William. Now we have a sort of multi-question question. I'll read it as quickly as I can. When entering into a JV or franchise or distribution arrangement, how extensive does the due diligence have to be? Do you have to diligence the entire group? Is it the same type of questions you would ask when purchasing 100% of a company, or is there anything additional or different to look into?
Well, it's certainly different. And going back to what I mentioned earlier, the difference between a joint venture, partnership, et cetera, from an acquisition or certain other types of arrangements is, again, it's like that marriage. This is not someone, you're not buying a car and then you walk away with the car and you rely on the warranty if there's a problem. This is your new partner. This is someone you have to work with. So yes, to me, the big difference is I think you have to do more diligence, and it's not just, again, the nuts and bolts. Use the car analogy again, checking the engine, kicking the tires, all that stuff. You really want to know what this group is like culturally, reputationally. And so I think that more due diligence is merited for a joint venture. And again, that's not necessarily, and when I say due diligence, it's not necessarily hiring lawyers and accountants to look into things sort of under the hood, but it's spending time to get to know your partner, your JV partner, and do you trust them? Do you like them? Do you enjoy spending time with them? I think that's a very important thing. For me, that's the big differentiator. You have to make sure there is the right fit, not only from a business perspective, but from a sort of business culture perspective and a personality perspective in many ways.
Yeah, thanks, William. Especially the cultural and the personality aspects. Definitely good advice. What is the first course of action to take when you've become aware that your counterparty is in breach?
If you go, I'm not saying go back to them now, but thinking back to what I put on some of the slides when discussing about what to do when a potential dispute arises, and that's start preparing. Gather information, discuss with your team members and the other stakeholders internally. Read the contract, understand what your rights are, and what both you can do in the event of a breach, what your rights are, but also what you have to do in the event of a breach. Because again, make sure you're not waiving your rights. If you've discovered something and then you have a limited period of time, you better make sure you get that claim in or reserve your rights before you miss out on the opportunity. And then agree on a strategy. And so that's what I was talking about also when just preparing for negotiations generally. Make sure everyone's on the same page. Make sure you know what you're willing to accept and what you want, so that you're prepared for those uncomfortable discussions you'll have with your counterparty.
How do you deal with the major change in management of your counterparty, which is now questioning things and not working as well with you as before?
Yeah, it's a tough question. So I'm not sure there's always one right answer, but I mean, I think it's sort of the same thing, what I was just discussing. You gather your information, discuss internally. The situation has now changed, and so think about what's acceptable and whether that's just continuing the relationship at all, whether that's acceptable, or saying, okay, having a difficult discussion with the counterparty and saying, okay, we're not entirely happy, and we understand things have changed on your end, and here is what we're struggling with, and think of the options that will hopefully allow a path forward. And then what you're going to do if you don't find a satisfactory solution. And then again, you have to go back to considering termination and what are the consequences of termination, how that can affect you on various levels.
Getting to the last two, how can you ensure continuation of a partnership or JV in the event of the death or incapacity of one of the partners?
It's a good question, and a question that's very important to ask early on, and because you're going to have to think about that and deal with that. And that's not just I mean, to me, I don't know if that question is meant where it's you actually have an individual who is your partner, is in a partnership, or if it's sort of a key person. I think it's all the same issue. It's very important that you consider how important that person is. For some types of arrangements, it doesn't really matter. It's the business that matters. It's the product that matters. For many business arrangements, it is that person. And whether it's because of their particular technical expertise or their influence and contacts in the market, you don't want to work with anyone else. And I think most importantly, make sure that it's clear if that key person, so make sure it's clear when you're drafting the agreements, if that key person is no longer there for whatever reason, whether it's death or incapacity, or whether they quit, they quit the company and go and do something else. What are your rights then? Do you have a right to terminate? Do you have a right to bring in a new partner? Do you have a right to appoint the new manager of the JV, et cetera? Very important. It's a very good question. Very important to try to deal with those questions from the outset.
Thank you, William. And how do you deal with a partner who owns a significant share of the business and is also the managing director?
How do you deal with that? I guess very diplomatically. I mean, hopefully it's a good thing that that they have skin in the game. If they've got a significant share of the business, hopefully that will mean they are invested in the success of the business generally. But obviously there are going to be situations where they may try to manipulate that to their own advantage and to the detriment of your side. So yeah, I mean, I guess if they're having a negative influence, and if they're having a positive influence, it's fine. That's great. If they're having a negative influence, I guess you just have to sort of see what your control rights are. And again, you have to be very diplomatic about that sometimes. See if you can remove them. See if you have rights to sort of lessen their influence or otherwise. And again, sort of the termination potentially as a last resort. So.
Okay. Great, thank you, William. Do you have anything more to add to the?
No, I don't think so. I mean, I know there have been some other questions that have come in, but I'm conscious that we're well over time, and I don't want to keep everyone too long. So okay. I think that's it from my end.
Okay, thank you, and thank you to all our delegates who have stayed back as well. I think it's such a crucial topic, so it's great that you've been able to sort of delve into it and offer great advice. So thank you once again, William, for sharing your practical insight and especially the illustrations as well. If the delegates have any further questions, please do reach out to William directly, or you can also send us your queries and we would be happy to forward it to him. Our sincere thanks to the firm Charles Russell Speechlys for leading the discussion. To the team at the firm, Hoda and Emma, thank you for your help as always for organizing the session. We would also like to thank our legal research partner, LexisNexis, for their support, and also to my colleagues at Niche Publishers, and especially to Sandhya Divakaran, co-organizer of this session, for your support this morning. A recording of this webinar will be available on the Oath magazine's website. Thank you once again for joining us this morning. I wish you good health and a wonderful week. God bless. Thank you, William.
Thanks, everyone. Thank you,
Thank
Ruthie.
you.
Thanks, everyone. Bye-bye.